Good morning, everyone, and welcome to the HR Buddy HR and Employment Law Update for May 2026. You're all very welcome this morning, and thanks for joining us. HR Buddy, of course, is an Irish-based HR consultancy, payroll provider, and HR software company. And I'm joining you this morning from the Killarney offices. However, of course, at HR Buddy, we work nationally to deliver flexible HR solutions to companies of all sizes and across many sectors, as well as supporting overseas companies with EOR services. Today, as I said, you're joining us for the May installment of our HR update series. However, if you want to stay up to date with the latest developments in the HR space, you can sign up to our monthly newsletter mailing list. You can see our contact details below on the screen, and I'll pop up a link later as well so you can connect with us, stay informed on all things HR and employment law, or drop us a query if you have one based on today's topics or any other HR matter that you want to discuss. Now, today's discussion, it's a timely one, and it follows the publication of the 2025 WRC annual report, which gives an overview of the state of play in terms of complaint submissions, inspection stats, and enforcement trends in Irish workplaces today. And this is information that employers need to know, as I'm sure people see the headline figures in the media on a regular basis in terms of awards at the WRC. And look, of course, we don't propose to run through everything the WRC does in terms of mediation, conciliation, and so on. But from a HR perspective, the report shows us that the WRC continues to deal with a range of issues across the employment relations space, and there are certain HR themes that do keep coming up. So today, we're going to run through some of those key takeaways, and for this session, I'm glad to be joined by my colleague Patrick Scanlon, who has compiled some of the main highlights from the report in terms of compliance risk areas, and some of the need to knows from this report. Good morning, Patrick.
Good morning, Colin.
And we're also glad to be joined by Breach Fallon, HR business partner with HR Buddy. And Breach is going to delve into some of the key learnings from WRC decisions and give us an update on what's happening in the world of HR and employment law today. Good morning, Breach.
Hi. Hi, Colin. Hi, Patrick. Hi, everybody.
Hi, Rich.
And look, we'll be flying through this and touching on a lot of topics this morning. So if you do have any queries on any of the topics that we go over today, we will have some time at the end for questions and answers on the topics discussed. So before I hand over to Patrick, if I can, I'd like to just give a very quick overview on some of the latest figures from the report and what those mean for employers. And what we do want to stress here is that the WRC is not something to fear. It's a statutory body. It's charged with ensuring compliance and fairness in employment practices. But what we can see from the publication of this report is that maybe there is still an approach from some organizations of look, we'll do things as we've always done, and we'll react if a complaint lands on our desk. But I think it's fair to say that that's not going to cut it in today's employment landscape. So when we look at the WRC's 2025 annual report, there is no doubt that the scale of activity is significant. The Commission received 10,500 complaint applications that represents 19,000 individual complaints. And what does that mean? Basically, that in the average is that there's generally two specific complaints per complaint application. So complaints are not being lodged just in terms of one area. There'll be several complaints contained within each complaint application. You can see there's a lot of activity happening there in terms of calls into the WRC. So last year, 64,000 inflow calls. That was up in the previous year. The complaint applications represented an increase on the previous year as well, and the specific complaints then. So the average is about two specific complaints per application. That was up on the previous year's report as well. Lots of inquiries into the information line, lots of inspections carried out last year as well, which we'll dig into that in more detail as well. So what is clear here is that people are looking for clarity. People are looking for information. I think in the AI age as well now, people are and employees and workers are very tuned into entitlements and what's happening out there. So it's clear that employers need clear and compliant policies. They need to retain accurate records, and they need to ensure that managers are suitably trained, so that they know how to apply processes, fair processes consistently. Because look, it can be a short step between dealing with an internal procedure or a grievance, or something of that nature, to a formal WRC complaint or case. And look, I guess complaint stats, maybe they can vary from year to year. So what we want to show you today as well is in terms of the trends. We've looked back over the last 5 years of the report, so that the WRC has been in operation for a decade now, and you can see that there was a dip there during the COVID years, but the average has come back up now again, and we can see a steady increase here year on year in terms of complaint applications to the WRC. So I think what we're saying here is that employers need to be ready with their policies, their records, their documentation, and their fair processes in place, and ensure that that's being carried out within the organisation. So 10,500 complaints in the 2025 report. What are those based on? If we can quickly look at the most common complaint areas from the 2025 report, the largest one was pay. And what does that relate to? That could be complaints around, we'll say, payment of wages. Maybe there's disputes around overtime, around alleged unlawful deductions, or maybe there's disputes around the calculation of pay or things of that nature. So what's clear there for employers is that you need to ensure that there's clarity around what's agreed, the method of calculation, deductions, and that there's clear, compliant policies, documentation in place to ensure that there's no disputes or escalations in terms of pay, because that represented the largest area in the 2025 report. Unfair dismissals again is a large area, represents a huge amount of complaints in the report. Patrick is going to dive into what that means in more detail in a little while. Some of the other headlines from the report is of course, equality complaints, which involves allegations of discrimination, harassment, or potentially less favorable treatment on any of the protected grounds. That remains a major part of disputes and complaints to the WRC on an annual basis. So employers, again, when we talk about procedures, we talk about suitably trained workers, managers, and so on. That all feeds into ensuring that there's fairness and there's equality of treatment within the organisation to avoid any escalation around those topics. Terms and conditions. This relates to if there's disputes around contracts, entitlements, maybe there's a lack of provision of contracts and HR documentation within the correct timeframes, or maybe there's policy changes or amendments to terms and conditions being introduced, which is not in line with what's been agreed, or maybe it's not being properly communicated or inconsistently applied, things of that nature. So there's been a large amount of complaints there as well, and that's something that we're going to dig into more detail as well, and Breach is going to give us more information around that topic. Working hours remains a key dispute area at the WRC. So complaints relating to rest breaks, maximum hours of working, rostering disputes, disputes around time worked, time recorded, bank holidays, and so on. So it's clear that companies need accurate systems of time and attendance recording, breaks, working hours, leave requests, things of that nature. Just clear that remains a common complaint area within this report. And then industrial relations it represents another large amount of complaints, and that relates to, I guess, look, the WRC. It is provided for in the legislation that they can hear issues around workplace conflict, grievances, collective bargaining, things of that nature. But again, if you're talking about clarity around ensuring that procedures are consistent and fairly applied, that's where organizations and employers are getting into difficulty and finding escalations to the WRC. So there's some of them from the report there that represents a large amount of the complaints that have been submitted in the previous year. Some other notable areas that we wanted to just briefly touch on that we see, I guess, coming up time and time again, and we do get queries on these matters as well. Protected disclosures. That's something that's, I guess, since the amendment to the protected disclosure legislation in recent years, it remains a key compliance area. It's an area that there are lots of disputes being taken to and complaints being taken to the WRC. So employers here need to make sure that they have fully updated whistleblowing and protected disclosure procedures and policies within the organization. And that's something that we do advise on and assist our clients with on a regular basis. Redundancy remains an area of contention in terms of ensuring that where the issues arise there, ensuring that a fair process is followed, the rules of fair procedures and natural justice and so on, and going through all the key criteria around selection, documentation, consultation, and so on. Sick leave is an interesting one. It's I guess it's recent enough legislation in terms of the Sick Leave Act, but it's something that employers need to be aware of in terms of ensuring that they have their policies updated. Is the policy outlined as 5 days, or does your policy and your handbook say something different? And is your policy in line with the statutory provisions in terms of entitlements, pay, the policy, and so on? And another area where we do see lots of issues arising, disputes and escalations is around fixed term contracts, part-time contracts, part-time employees. There is legislation in place in terms of ensuring that fixed term or part-time employees are not being treated less favorably. So complaints here center on contract clarity, whether workers are being handled in line with the statutory protections outlined in the legislation. So I guess employers just need to make sure that they're operating within the legislation and ensuring that contracts issued are compliant and are clear as well. The key tip there is that most complaints escalate when issues maybe they're ignored, maybe they're inconsistently handled within the organization, maybe there's poor levels of documentation and recording of issues or resolutions. So what we recommend here is that clear procedures, effective training, and a consistent approach to issues is the best defense and the best route to resolution. One further point we want to touch on here in terms of the trends is that the area of inspections. So as I saw on the first slide, it was over 5,000 inspections last year, which was up again on the previous year. And the WRC carry out inspections across a range of workplaces to ensure that employers are operating in compliance with employment law and that all employees are in receipt of all their legal rights. We'll share these slides as well today, but just wanted to give you a quick snapshot of where the WRC focused and the inspectorate focused in 2025. You can see that around 70% of the inspections were made up in terms of food services, wholesale and retail, but it covers a whole range of different sectors there. So 5,000 employers inspected, 1,775 were found in breach. The compliance rates varied across different sectors. So the inspectors are empowered to enter any workplace. The employers and people operating within those workplaces are obliged to cooperate and provide information. And as part of that inspection process, the inspector they're gonna look into employment related records, contracts, and so on. They may interview employees or employee representatives, and they'll look to seek relevant information in terms of employment that's operating within that organization. So I guess the headline there is that enforcement is active. It was up on the previous year again, and employers are required to either be compliant or make themselves compliant during the process. Failing that, there could be compliance notices issued, fixed payment penalties, or even prosecutions. So it's important to be inspection ready, and we are here to assist in that regard as well. Employers may ask us from time to time as well, what constitutes or am I likely to be inspected? Well, you can see just the volume in terms of 5,000 inspections last year. So it's employers are advised to ensure that they have everything in place to be compliant in the event of an inspection. Um, Inspections generally come from like the WRC are very active in terms of their own campaigns, whether that's focusing on specific industries or on maybe areas that have been shown to be less compliant in the past. Also carrying out risk assessments. Also, it can come from individual complaints. It can come from referrals from the employment permit applications, other agency referrals, and so on as well, or working with different departments in terms of Department of Justice, Social Protection, and so on. So, as we said, it's important to be ready and to be audit ready and have everything in place. So we're available to assist our employers and organizations in that regard. So that's just a very quick tour of the headline stats of the report. Um, we'll share the slides. If you have any questions on anything that came up there, please drop it into the Q&A and we'll answer those at the end. So with all that being said, I'd now like to hand over to Patrick, and he's going to dive into some of those areas in a little bit more detail.
Thank you, Colin. Very insightful run through of the WRC report. So this morning I'm just going to look at some of the areas that are high risk areas for compliance, especially in terms of WRC compliance. And the first area I want to look at there this morning is in relation to employment permits. So 40% of calls to the WRC helpline last year were in relation to employment permits. So we thought it'd be quite useful this morning to go through some of the more common queries that we get here to the office. The first of all, there is who exactly needs an employment permit. So typically speaking, anybody from outside the European Economic Area will need an employment permit to work in Ireland. Individuals from the UK do not need a permit to work in Ireland as per their rights under the Common Travel Area, as well as Swiss nationals do not require an employment permit either. So any individual outside the EEA, bar the UK and Switzerland, generally needs an employment permit to work in Ireland. Also, non-EA spouses or dependents may not need a permit if they're a spouse or dependent of an EA or Irish national. Who is responsible for ensuring that employees have the authorization to work in Ireland? Well, it is up to the employers. It's not the responsibility of the employee to prove their authorization to work in Ireland, or they won't be held responsible for it. It's up to the employer themselves to prove to the WRC that this individual employee has the authorization to work in Ireland. So we always recommend clients that they complete a right to work check prior to employment, and you will do this for all candidates, whether they're from the EA or outside the EA. And typically what this would involve is that you would ask an individual to see a copy of their passport and ID card, confirm in writing that you have seen it, and maybe perhaps note something such as the passport number. For individuals outside of the EA as well, you will need a copy of their employment permit or their stamp permission if an employment, excuse me, or if they don't require an employment permit. Also, a copy of the individual's residence permit is required. And I said you will do this for all candidates, regardless of their nationality. Just to go a little bit deeper into terms of employment permits, there are 9 types of employment permits within Ireland. I won't be going through them all this morning, but some of the most popular types of employment permit are listed here. For example, a critical skills employment permit. This is granted for 2 years and is granted for roles that are highly sought after within Ireland. So they would be highly skilled roles such as IT roles, engineering roles, healthcare. So a critical skills permit is granted for those highly skilled roles where the skills are in high in demand in Ireland, but we have a labour shortage in that particular role or skill. Another type of permit is a general employment permit, and this would be granted for roles that are eligible for a permit but are not necessarily a critical skills role. A general employment permit defers to critical skills in that a labour market needs test is required before you can apply for the general employment permit. And what this involves is basically advertising the role on the Department of Social Protection website as one other platform, such as Indeed.ie or JobStudy for 30 days before the application is made. Just to briefly run through, another type is an intra-company transfer employment permit. This might be used by a multinational company who wants to transfer a non-EA employee to the Irish branch for a limited period. And then there's a reactivation employment permit as well. So this is granted where an employee entered the permit system in Ireland legitimately working for an employer. That employee they might have fallen outside of the permit system. For example, they might have worked for an employer who didn't treat them well. Well, the reactivation employment permit allows that individual to re-enter the Irish employment workforce in a legitimate manner. Um, Moving on, permit actions. What happens when an employee on a permit ceases in my employment? Well, employers in that case will need to notify the Department of Enterprise, Tourism and Employment within 4 weeks of the cessation. So, regardless of whatever reason the employee finishes with the employer, the employer needs to notify the department within 4 weeks and return a copy of the permit. Record keeping is also a highly important permit action. So when the WRC arrive, you will need to prove that anybody who needs to have a permit has such permit or stamp permission on file, and it is valid and up to date. Where a work permission is out of date, both the employer and the employee will be legally responsible. So just our own key reminder this morning is that where you do have individuals on permits or stamp permissions, or it's best to complete an audit as to ensure that you have the correct documentation in place, and that it is up to date. Moving on to the next slide. So to tie in with employment permits and with the time of year, we find that many employers are now hiring individuals for seasonal work, and there is such thing as a seasonal employment permit. So this is granted for periods of 3 to 7 months with over a 12-month period. So if an individual is to be granted a seasonal employment permit, there needs to be a gap of 5 months between one permit and another. To avail of this permit, you need to be a registered seasonal employer, and also a labour market needs test is also required for this permit. Where seasonal employment permits are granted, there is further obligations on employers in that you need to provide accommodation, private health insurance, training, amongst other things. Individuals on hired as seasonal workers, they're going to be fixed term workers as well. So just another point I want to make this morning is that fixed term workers can be treated no less favorably than comparable permanent employees in terms of the conditions of employment, unless there is objective justifications. So typically speaking, fixed term and permanent employees need to be treated the same for conditions such as pay, holiday entitlements, sick pay, working schedule, training, promotion prospects, amongst numerous other things. But they are just some of the things that employers need to be cognizant of when hiring workers on a seasonal basis. So moving on to the next slide. Also typical at this time of the year is that we find that many clients are hiring individuals under 18 years of age on seasonal work. So where an employer applies or where an employer employs somebody under 18 years of age, that they need to be aware that there are different pieces of legislation that apply to those under 18, particularly the Protection of Young Persons Employment Act 1996. So there are differences in terms of working times, nighttime work limits, weekly rest breaks, daily rest breaks. So just to briefly run through some of those, for 14 and 15-year-olds, the maximum working week is 35 hours and the maximum working day is 7 hours. For those 16 and 17 years of age, the maximum working week is 40 hours and the maximum working day must be 8 hours. There are also nighttime work limits for those under the age of 18, where those individuals can only start and finish at certain times. There is differences as well between the school time of year as well as holiday times in terms of those shift those nighttime work limits. For individuals 14, 15 years of age, they need a 30-minute break after 4 hours work, or for 16, 17-year-olds, it's a 30-minute break after 4.5 hours work. Before an employer takes on somebody under the age of 18, you will need to see proof of their age. So that would typically be a birth cert or passport. Um, Also, if you're to employ somebody under 16 years of age, you need written consent from a parent or guardian. Furthermore, a copy of the Protection of Young Persons Employment Act 1996 needs to be provided to the employee, for any employee who's under 18 years of age. A copy of that is available from the WRC website, or you can also reach out to us here at HR Buddy, where we will provide you the required copy of that act, which is basically a breakdown of the employee's rights, a young person's rights, when they're employed where they're under 18 years of age. Um, Now, the full provisions of this act don't apply where the young person is employed by a close relative. Further to that, there are also different provisions when it comes to the national minimum wage. So somebody under the age of 19 doesn't have to be paid the full national minimum wage. Now, employers don't have to do this, but they may do so if such. For example, somebody under 18 years of age needs only to be paid 70% of the current full rate of the national minimum wage. So moving on to the next slide again. Just in relation to the WRC report itself, we saw 17% of complaints to the WRC related to unfair dismissal. So this was the second most common reason for referrals or complaints to the Workplace Relations Commission. I suppose the first, in relation to unfair dismissals, I could do a presentation, or I could do content in this for you all day long. But for the purposes of the webinar this morning, I just want to run through what is known as the principles of natural justice, just on the right of that slide. So those principles, they need to be enshrined into disciplinary procedures at all stages, regardless of the conduct of the employee. To briefly run through those, the first right is to know the case. So where an employee has an allegation made against them, they need to know the full facts of the allegation and any evidence to support that allegation. The employee then has the right to respond to those allegations in having their own version of events heard. So that will be typically at an investigation meeting or disciplinary hearing if you get to that stage. The right to representation. So when an allegation is made against an employee, they have the right to be represented throughout the disciplinary procedure, typically by a work colleague or trade union rep. Separation of process. So where there is a disciplinary procedure, there needs to be a different individual involved or different individuals involved at each stage of the disciplinary procedure. So nobody can be judge, jury, and executor. There needs to be different individuals involved at the investigation stage, at the disciplinary stage, or at the appeal stage, if you even arrive at those stages. Reasoned decision making. So where a decision is made, it must be based on the employee's responses, their own version of events, witness statements, any evidence. They must be all taken into account so that legitimate, reasoned, logical decision is made, which can include up to and including dismissal. So when a complaint is referred to the Workplace Relations Commission, the WRC won't judge as to whether the employee was guilty or not in terms of the allegation brought against them. The WRC will assess if the decision to dismiss was fair, considering all the circumstances. And I'll speak briefly about that in a little bit more detail in a moment. And the final right that I want to go through is the right of appeal. So any decision made following the disciplinary hearing, such as a decision to dismiss or even a decision to issue a warning, the employee needs to have the opportunity or the right to appeal that decision. Moving back to the left of the slide, so ensure a documented procedure. So I suppose it's no good providing all these rights unless you can back up that you have unless you can back up with documentation that you can prove that you've afforded all those rights to the employee. Run your own company disciplinary process. So it's important that companies follow on their own disciplinary process, and this typically or should be given to the employee at the onset of employment initially as part of the employee handbook. Ensure the decision to dismiss is fair considering all circumstances. So, as I said, the WRC won't assess as to whether the employee who was dismissed is guilty or not. They will assess all circumstances, including as to whether the company followed their own disciplinary procedure as well as the employee's previous record. Did they have any other warnings on file, or have they committed gross misconduct recently in the past, for example? Um, Seek professional HR support. So, running a disciplinary procedure, it can be fraught with risk, and it can be quite complex. So there's a lot to consider when running a disciplinary procedure from start to finish. So it's always best to seek professional support when doing one of these. That's something that we here at HR Buddy will be gladly able to assist you with, so we can mitigate or avoid any risks as part of running a disciplinary procedure. As mentioned, the code of practice on grievance and disciplinary procedures, your own policy needs to align with that, as well as the rights or the principles of natural justice that I just spoke about. So again, if you need assistance with that, that's something that we'd be glad to help you with here in HR Buddy. Uh, Finally, moving on. Just moving on to the next slide. So this morning, I just want to wrap that up, just in to talk about an employer action checklist. So, if we're just moving on to the next slide. So, there is a lot of onus on employers to not only be compliant but prove that they're compliant. And the best way to do that is have records in place. So when a WRC inspector does arrive to your business, the only way that you can prove that you are compliant is by having the records in place. So we've just listed some of the records that you need to have in place to ensure that you are a fully compliant employer. Some of those include some of the documents that WRC or that you need to have in place include policies, procedures, as well as HR documentation. Um, those are things that we can assist you with here in HR Buddy, or if you have those in place, we can help you ensure that they are kept up to date. Other items include payroll compliance, tracking hours and leave, which is a very important one when it comes to WRC inspections. Fair procedures applied, as well as employee leave compliance. So this is just a tip of the iceberg in terms of employment records that need to be kept on file for in terms of WRC inspection. Um, how the best way to ensure compliance is ensure that you have a one-stop shop for all your documentation in place for all employees. And the best way to do that, we always advise, is our own HR system, HR Buddy Manager, which contains a file locker for all employees with unlimited cloud storage, where you can maintain your employment records for that individual employee, as well as other working records across the company, such as payroll records, annual leave records, hours of work records. So having a HR system in place like HR Buddy Manager makes life not only easy for yourself, but also for WRC inspectors, to their satisfaction that you are a compliant employer. In terms of the HR Buddy Manager system, there's information on it available on our website in relation to the software. There's also the option to sign up for a 14-day free demo, or you can reach out to any of us on the webinar here this morning, myself, Bridge or Colin. I would be happy to do a demo for yourself. I'm now going to pass you on to Bridge, who will go through some of the upcoming legislation within the HR landscape.
Thank you, Patrick. That was very insightful. So just moving on to my section, I just have a few slides to go through on a couple of topics. And the first one is being the EU Pay Transparency Directive. I'm sure most of you maybe are joining us on a monthly basis and you're keeping in touch to see what updates are in the pipeline. So, as you all know, the EU Pay Transparency Directive was due to be incorporated into law by the 7th of June, which is just under a month away, really, now. And there is no update. Really on this topic. So I'm sure that there will be an update any day now in relation to it, but at the moment, the government haven't come out with the framework that they said they would. So as you all know, the purpose of the directive is to promote equal pay for equal work and reduce the gender pay gap. So in March, the Department of Equality acknowledged that the required measures and supporting tools would not be implemented by this deadline. And they were going to introduce them on a phased basis, which I have outlined previously in our last webinar. So the department have come out and they have advised that employers will not be penalised for having all elements of the directive implemented or completed by the June 26th deadline. And just to kind of, I suppose, recap on like what are those per the next slide, Colin. So then what they are is like gender pay gap reporting. So that's annually, that has to be done by employers that have over 50 plus employees. Pay structures, so to ensure equal pay for equal work. Job advertisements, so the initial pay level or salary range not permitted to ask about like the candidate's previous or current salary. Pay transparency, so pay secrecy clauses are to be prohibited, so employees will no longer be asked to have confidentiality in this regard, so they can talk about what rates of pay they're on and so on. And then the pay data request, so employees may request average pay levels broken down by gender for employees doing the same work or work of equal value, and the employer must respond within 2 months. So these are the key areas and requirements that are going to fall under this the EU Pay Transparency Directive, but it hasn't come into law yet, and we're still waiting update. Just on that, I would just like to note like the gender pay gap reporting is important, and a lot of employers need to be aware that they should do this and have the information in a publicly accessible area or on their website. And at HR Buddy Manager, we do have a function for this on our software. So our software, as you know, can record clock in, clock out, annual leave, holidays, sick pay, but also it has a gender, it can also be linked to your payroll software. And then there is a gender pay gap reporting section on it where all the data is all linked, and you select print the gender pay gap report and it can do all that work for you. So that's just one of the advantages and the easy functions of it. So just to make you aware of that. So just going on to the next slide, it's just saying about what should be phased in, and the likely changes are going to affect like the recruitment and the salary transparency. So one, it is thought that it will be about providing candidates with information on pay levels or pay ranges in advance of employment, and two, prohibiting employers from asking candidates about their pay history at interview. So these are the two areas that they say will be phased in. But like I said, it's under a month away of this deadline, and we still don't have a firm update on it. But that is what they say from the last update that we got, that we think will be phased in. So in March, the EU published guidance on 26th of March on how employers should assess and compare roles for equal pay, and Ireland is expected to finalise and release its own tools and employer workshops planned. So that was between April, which didn't happen. So any day now that should be coming out, and that will be up to so from I suppose now up to July, they're going to be helping employers prepare for it, and they're going to come out with these tools. And when they do, we will be ready and waiting and looking at that. We also have training that we can do on this topic for employers about the directive and the workshops. So employers should still continue to prepare for this directive. You know the key areas and the key requirements that we've all outlined. So it's important to just be looking at putting equal pay and measures in place for all your employees. That's that section. So just moving on then to the pregnancy loss leave bill, and that was just introduced, I suppose, there recently. But before I go on to that, there is currently no loss, no specific statutory entitlement to paid miscarriage or pregnancy leave in Ireland. Employees experiencing pregnancy loss generally rely on sick leave, force majeure leave, annual leave, or employer discretion, such as like compassionate leave and so on. But the important point is that there is no leave for this. And there is a bill that has recently gone to be approved at the moment, and it's called the pregnancy loss leave. And that was introduced there recently. It is not approved yet. It's on the next slide there, Colin, if you just want to move on. But it's not approved yet, and they think it will be July by the time that the reading will go ahead. But if that does go ahead, it's 5 days statutory paid pregnancy loss leave for pregnancy that ended under 23 weeks and 2.5 days for partners. So, as I said, it's under legislative consideration. We're just advising you on this bill so that you're aware of it. Then you might have been confused because that is there in the media, but then in the media they're also talking about another bill. So the other bill was introduced prior to that, and that was by the Labour Party, and that's called the Reproductive Health Related Leave Bill. So it's a separate bill. And that was put in, and they felt that the 5 days was not enough, and they didn't think that was enough for somebody experiencing that loss. So they thought 20 days was more reasonable. So they put in for 20 days paid leave for early miscarriage and 10 days for fertility, IVF treatments, and so on. So as of March, that was not passed by the government, and it is still under review, but the government have put in their bill, which is under consideration, but there'll be no update on that until July. And this is topical because we want to make you aware of the bill and what's happening and the difference between the two bills. But then, as of the 6th of April, just there very recently, Northern Ireland introduced statutory paid miscarriage leave. So employees and partners experiencing miscarriage before 24 weeks are entitled to up to 2 weeks statutory paid leave. So they have come in and introduced that. So maybe possibly Ireland will follow suit, and possibly it could be in the pipeline because of that bill has been introduced. So what can employers do to help in this situation, or what steps can they take? Firstly, it's important to say that you're not legally required. Employers are not legally required to put support or to put a policy or, I suppose, paid leave in place. But if they want to do so and look at things within their organization, you can look at the pregnancy loss or compassionate leave policies. You can put something like that in place. You can look at flexible working arrangements. You can look at temporary workplace adjustments and employee assistance program and counselling supports. So these are some options that employers could take into consideration for their employees or partners experiencing such a loss. And the employee assistance program, I'm sure many employers do have that in place, but it really is a great resource and support to have within a company for employees to be able to reach out on various topics, such as they could be having financial issues, they could ring up and talk about that, they could be experiencing difficulties at home, or they could be returning from leave, from maternity leave, and so on, and they can have these employee assistance programs where they can ring up and get support on these topics, or the pregnancy loss as well. So that's just if a company did have these supports in place, and that would be helpful for their employees. And then just moving on to, I think it was a summary of a case. It was kind of related to the unfair dismissal slide or topic that Patrick spoke about earlier. So it was just a case, and just highlights the risks employers face when attempting to impose contractual changes. So this was a case that there was an overlap between pregnancy and redundancy. So the employer came in, he acquired the new business. He discovered that it was suffering, there were significant financial difficulties within the company, even though he allegedly had done due diligence in advance, but allegedly he didn't know how serious it was. So then he sought to address the issues by announcing salary reductions within the team. So prior, it was also noted that the previous employer that he took over from high salaries within the business were a significant problem for the previous employer, and he did know that going into the business. So what he did was he, prior to the salary cuts announcement, with the complainant who took a case and won it, she was earning a high salary, 64,000. She had 6 years service, and she informed the employer that she was 25 weeks pregnant. So this was before he put in announced the cuts for salaries. And then when indeed she was issued with the new contract, and she was cutting her salary to 24,000, which was below the minimum wage at some point for what she was on. So he was removing her continuity of service. So he put in a new start date, and he put in a probation period, even though she'd been in the job for 6 years, which you cannot do. And he put in the new start date. So he just totally disregarded. He thought he was a new employer, and he was giving her all new terms and conditions. So she received the contract. She then put in a grievance about the proposed changes, and she was informed she was being made redundant. So just about 4 days after the process begins. So she put in the grievance, had her issues, and then he went back to her and said that she was going to be made redundant. So there was no consultation, there was no fair procedures, there was the process, I suppose, it lacked real meaningful consultation, and there was no selection process, and she was never advised that she was at risk. And that is, if you're ever making somebody redundant, it's very important that they are advised that the role, it's not them, but it's the role is at risk of redundancy. And there was a consultation period, and none of that happened. And she also had no right of appeal in this case. So she was awarded compensation of 30,000. The WRC also took into consideration, when they were coming up with the compensation, about her looking at other roles and how much work and she put into applying for other roles and trying to secure further employment. They also took into consideration the fact that she was due to be paid maternity pay, a proportion of her salary when she was on maternity leave, and she did not get that then. So she got the statutory amount, but she didn't get the amount that she was supposed to get because her job was gone by that stage. So they take into consideration all these points when they're reviewing it. And the next stage then, I suppose, is just to advise employers about, in this situation, that, like, if there's financial pressure within a business, it doesn't remove the obligations to follow fair procedures. You must engage in proper consultation and respect maternity protections, or lawfully vary contractual terms before you do such a thing, even if there is financial pressure. And always remember that, redundancy is such a protected area, but maternity and employees on this type of leave, it's very protected legislation. So just to be cautious. And thank you so much. I don't think there is anything else, and that's after that there, Colin. Thank you, everybody.
Thanks so much,
Thank you,
Breach.
Bridge.
And yeah, it's great to get the update on what's happening in the HR space, and lots of information shared there as well. And yeah, great to get the deep dive from Patrick there as well on the different compliance areas. And I guess if we have time now, we might dive into. So I was looking at the Q&A, quite a few questions came in there while we were going through the different topics. If I can take the one there that relates to what I presented on there, folks. My understanding of that question there's a question here about the 5,000 inspections, and my understanding of that is that the inspections, do the 5,000 over 5,000 inspections flow from the 10,500 applications? I think the answer to that is that there's different sections within the WRC. We have the information and advice service where people can phone up and get information on their entitlements and so on. You have the mediation and conciliation service and so on. And then you have there is an adjudication service that, so the 10,500 applications or complaint submissions, they flow in there, they're adjudicated on by independent adjudicators. Does that flow to the inspectorate? It can, and we saw that some that was the basis of some inspection in terms of maybe there was it flowed from a complaint or a request, or maybe the inspectorate saw that there was some areas where there was a high level of breaches in terms of compliance and so on. So maybe that does flow down to the inspections. I guess what we want to show today is that inspections are ongoing and they're active. There was over 5,000 last year. They focus in on maybe there are certain industries that there's initiatives and projects in terms of enforcement and information. Maybe it flows from risk assessments and other areas. But I guess what we want to show is that yes, inspections are happening, and also look if there was 10,500 complaints submitted last year, and we can show you the different areas where those where our employers and organizations got themselves into difficulty in terms of whether it's pay or whether it's dismissals, terminations, and so on. I guess the key topics there were, and what jumped out from Breach and Patrick's presentations there was around ensuring that the HR documentation is in place, record keeping is correct, people are suitably trained, and that the fair procedures and policies are in place and consistently applied. So we want to, I guess, if we can take learnings from the report and apply them and avoid difficulties and ensure fairness and consistency and clarity in organizations, that's the goal, and we're here to support on that as well. So I hope that answers the question.
Perfect. I will just jump in there. There was a question about gender pay gap reporting, and it said, does this need to be published now, or are we waiting for updates with the Transparency Directive? So gender pay gap, just to recap, I didn't mention it today, but because I didn't go into the gender pay gap reporting in detail, but over 250 employees, companies with that first reporting year for the gender pay gap reporting was in 2022. If you had over 150 employees, you had to report in 2024. And if you had 50 employees, first reporting year was 2025. So once an employer has 50 plus employees, the obligation is annual. So you have to do it annually. So if you're asking when do you have to do it, employers select a snapshot date in June each year. So reports are published then within 5 months. So that would be by the end of November. So I suppose that's coming up to it now. It's May. So employers, if you have this amount of employees, you need to be selecting a snapshot date in June. And then come November, then that will be when it's published on the website, publicly accessible area. And then also just to say that what happens if the data changes. So if you've maybe updated someone's pay rate or you notice that they weren't on the same level, but now you've changed it, you can't go back in and edit that. But you could put a note beside it saying that there are differences, but they will be rectified by such a date. So it's published on the employer's website, as I said, and then the gender pay gap portal launched in 2025 on a voluntary basis, but it's intended to become mandatory from 2026. No update on that yet. There was just another question then. I'll just briefly say, where can we find out about the workshops and are they available for all businesses? So yes, they will be available for all businesses and they haven't yet come out with it. That was just in recent months. They've said that from April sometime they were going to start publishing data about it. Because the EU have already published their directive. So we're waiting for our government to come out with the legislation and advise and help employers about their workshops. So we haven't got it yet, but I do believe any day now or in the coming months or weeks, we'll definitely have an update about that from the government. It'll be online and even by our next webinar, I'm sure we'll have an update.
So another question that came in there just in relation to public holiday times. It's not related to anything we spoke about this morning, but it is an interesting question nonetheless. For employees who work 40 hours a week over 4 days, what is their entitlement when they work on a public holiday and are paid for the public holiday on top of their daily rate based on 10 hours? Are they paid a public holiday of 8 hours, which is a fifth of their regular work week, or 10 hours based on their last day worked? So really, I suppose the way that should be treated is that it depends on when the public holiday falls. If the public holiday falls on the employee's normal working day, then it would be 10 hours. Or if the public holiday falls on a day that the employee doesn't normally work, it will be 1/5. They would be entitled to 1/5 of their working week. So that would be the 8 hours. So where the public holiday doesn't fall on a normal working day, they'd work their 4 regular days anyway. and they'd receive payment for those 8 hours in addition to the 40 hours because the public holiday has fallen on a non-working day. Um, just another question as well that came through. How often should handbooks be reviewed to ensure policies are up to date with legislation? So, as you've seen from this webinar and previous webinars and updates from ourselves, legislation is taking fast, particularly in recent years. And there's plenty more coming down the line, as you saw from Breach. So the way I treat a handbook is that the handbook is a live document. There is no specific answer really as to how often a handbook should be updated, but it should be updated regularly. For example, you might find that if you haven't updated your handbook in over 1 year, then the likelihood is that your handbook will be now out of date. So regular updates are important to ensure that your handbook is live up and up to date, not just with employment legislation, but maybe perhaps with some company policies as well that may have changed.
Perfect. There is another question there. I was just saying that somebody had a concern about related to EU pay transparency, and they said, I know the official start date is 7th of June, but Ireland is not officially ready. What basically happens on the 7th of June? Can some automatically audit a company to see what we have pay structures, etc., or is it more about having items like the recruitment lined up as policies? But the pay structure matters. Can this be addressed more gradually in case an employer has issues before the 7th of June? So what I'd say about this is that the government still haven't come out, they still haven't announced it, but what they did announce a few months ago was that it will be phased, and they have said publicly that that employers will not be penalised for having it. But it has been said that it will be phased in, and the two first areas that will be phased in would be not asking people about their previous history, relating to their salary, and putting the salary amounts or what the salary will be on the job adverts. So I would say for employers as of the 7th of June, you should definitely be doing those two areas and make sure that that the job advertisements and that the interviews are in line with those two phased parts, and keep preparing. They have said employers will not be penalised for not having all the areas of the directive. And if they haven't come out and given us guidance and legislation, then how can employers properly prepare? So I would say just keep preparing, putting your pay structures in place in relation to all those areas, and you won't be penalised. But if you just focus on those two for the 7th of June and everything else, just be preparing in the background. Okay, I hope that answers that question.
Just and wanted to jump in on one other question that came in there, Rundine. Can you clarify for me the employment permits procedures? Is it advisable that all applicants get asked for an ID documents to prove their residency? So the way I treat that is that a good starting point in terms of the recruitment is ask for a copy of perhaps the employee's passport or some ID card, first of all, that will prove their nationality. Like you don't want to be making assumptions that an employee needs to have a permit, perhaps based on their name or where they're from, because they might actually be an Irish citizen. So the best or an EA citizen. So the best starting point is to get a copy of the passport or see a copy of the passport, for example. And if that individual is then from outside the EA, then you can explore what their work permissions are in Ireland, whether it be a permit or a stamp permission, and then that can be kept on file.
Yeah, if I can just echo what you've both said there, folks, in terms of the obviously the updating of the handbook is required, I guess, because there's been such major changes to employment law and HR policies over the last number of years. In terms of if we just look to pension auto enrollments, sick pay was another major one before that, various codes of practice and so on, and now the EU Pay Transparency Directive represents another major shift in requirements. So important to keep the handbook up to date and be working towards the implementation of the pay transparency. And yeah, if there's any specific query that somebody has, and we have an opportunity to address it there, what I would say is we have a QR code there. You can that'll take you to our contact page, and we'd be more than happy to assist you and dive into your HR issues or answer your queries. Just get in touch.
Perfect. And somebody asked if we were sending on the recording. The notes, the slides will be sent on definitely afterwards. That's it.
All right. So I think we've covered an awful lot there today. As Bree said, we'll share the recording, the notes, and everything else. And if anyone needs any other assistance, get in touch. And thanks so much for joining us, and thanks for listening today.
Thanks everyone for your time. Thank you.
Thanks. Thanks for joining.